India Legal presents Courts Roundup.
Hello, I'm Hisha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. Supreme Court overrules Allahabad High Court order holds Masters of Education is a postgraduate degree and not merely a training course, says matter of education must be left to educationists. Supreme Court issues notice in a PIL seeking for age-based access to social media to eliminate illicit content on social media. Supreme Court issues notice in Yatin Oza's plea against recall of senior advocate's designation, says we will try to find a solution. And Jammu and Kashmir High Court orders CBI inquiry against high-ranking government and police officials for alleged encroachment of public land.
India Legal presents Courts Roundup.
Matters of education must be left to educationists, observed the Supreme Court, while setting aside an Allahabad High Court judgment which held that a Master of Education qualified person could not be appointed to the post of Assistant Professor in Education. A three-judge bench held that M.Ed degree is a postgraduate degree. Uttar Pradesh Higher Education Service Selection Commission invited application for the post of assistant professor in various subjects, including education. Later, the UPHE SSC issued a corrigendum which clarified that M.Ed degree can be treated as an equivalent degree to MA education for the purposes of appointment to the post of assistant professor. The High Court, allowing the writ petition filed by a few candidates, quashed the corrigendum and observed that while MA education is a master's degree in the subject concerned, M.Ed is not so, as it is only a training qualification. In appeal, the bench comprising Justices Sanjay Kishan Kaul, Anuruddha Bose and Krishna Murari noted that M.Ed qualifies itself as a master's program in education and is even recognized by the UGC and NCTE as such. The court said the issue of equivalence has been rightly considered by the NCTE, and while recognizing some distinct aspects of the two degrees, it had clearly stated that for the job of assistant professor education, both are eligible. The court, however, clarified that it is not as if a person with a M.Ed degree is eligible for all the posts which were advertised for science, arts and others. We are now joined by Advocate Divyanshi to update on this matter.
Yes, in this matter, Honorable Apex Court has set aside a judgment given by Allahabad High Court, which has held that M.Ed qualified person cannot be appointed to the post of Assistant Professor in Education. On this, Honorable Supreme Court has held that matters of education must be left to educators. And there is no doubt about the M.Ed degree being a postgraduate degree. It is a postgraduate degree and that can be treated as an equivalent degree to MA education for the purpose of appointment to the post of assistant professor.
Thank you, Divyanshi, for the update. The Supreme Court bench of Justices Sanjay Kishan Kaul and Dinesh Maheshwari has issued notice in the plea moved against the recall of GCHAAA President Yatin Oza senior gown by the Gujarat High Court's full court. after suo motu contempt proceedings were initiated against him. On October 6, the Gujarat High Court pronounced Oza guilty of contempt over his allegations of corruption by the court's registry during a Facebook press conference. The appeals filed over the issue has now been fixed for further hearing on November 5th, and while doing so, Justice Kaul orally observed that between the experience shared by the court and the senior counsel appearing in the matter, a solution may be worked out to give a quietus to the case. However, the hearing also saw Justice Kaul express anguish over the acerbic tone noticed when it comes to disagreement. In the course of the hearing, the judge observed ultimately the bench merges with the bar only, but there has to be application of mind for both sides to see that the working of the institution takes place. Normally, we are able to balance these things out. Vishwanathan submitted that it is not as if the matter is incapable of resolution, pointing out that the Oza had only taken up the GSCAA's cause. Dev submitted that while the High Court cannot be faulted for its judgment, one does feel a little sad when looking at the penalty that the High Court has imposed. The matter is now expected to be taken up on November 5th. And the Supreme Court has issued a notice in a PIL filed by 2 law students seeking for age-based control of access to social media and for the development of a profile verification mechanism to eliminate illicit content on social media. The plea also prays for action against those social media accounts which are involved in the online trade of illicit content, such as engaging in obscene content and online harassment videos. Additionally, in order to curtail mobbing of pictures and videos as well as revenge porn, the petitioner have requested the court to enact gender-neutral laws and for the criminalization of impersonation so as to protect an individual's identity. A bench headed by Chief Justice of India S.A. Bobde issued notice on the plea. The PIL prays for legal proceeding to be instituted against those users who indulge in advertising, sale and procurement of illicit content and private graphic information. Further, it states in that an effective mechanism should be formulated for such content to be deleted and not to be uploaded in the future, stating that there has been a proliferation of fake accounts which facilitates anonymity and impersonation. The plea seeks for guidance to enact a method for checking such social media profiles, as verified profiles would aid in encouraging accountability and would discourage individuals from engaging in cybercrimes. The Delhi High Court has dismissed the plea of IMA cadet who was relegated and was ordered to withdraw from the IMA on 23rd of November 2019. The court observed that the IMA had acted strictly in accordance with the rules in respect of the punishment, the relegation as well as withdrawal. The father of the petitioner, a Lieutenant Colonel, made a fervent plea to consider the case of his son leniently, as the commissioning of his son as an officer of the Indian Army meant a lot to him, as it would be the 4th generation from his family to join the Indian Army. To this, the court said, while it may be possible for us to sympathize with Lieutenant Colonel, but it is not a father's ambition that defines the standards for selection as a commissioned officer in the Indian Army.
While observing that the petitioner is not suited to a military lifestyle and possibly the desire of his father pushed him into this, the Delhi High Court had advised a lieutenant colonel and the father of the petitioner to allow his son the freedom to choose his life path and allow him to blossom forth in whatever he so chooses, which is certainly not the Indian Army. The bench of justices Asha Menon and Rajiv Sahai and Law made these observations while hearing the plea of a young aspirant to the Indian Army. After clearing the Combined Defence Service examination conducted by the Union Public Service Commission and the interview conducted by the Service Selection Board (SSB), including medical fitness, the petitioner joined the Indian Military Academy (IMA) on 8th of July 2017 for his pre-commissioning training to join the Indian Army as a commissioned officer. Unfortunately, the petitioner was subjected to ragging and was admitted to the hospital from 17th July 2017 to 26th July 2017. On 27th July 2017, he also filed a complaint against the ragging and the inhuman treatment that he had been subjected to by his senior. He did complete his first term successfully and was promoted to the second term along with his batchmates in the 143rd regular course IME. However, a week before the second term came to an end in May 2018, the petitioner was served with a notice to show cause as to why he should not be relegated for having accumulated 60 restrictions in 2 terms from 8th July 2017 to 30th May 2018. Despite his reply, the petitioner was relegated and completed his second term after repeating it with the 144th regular course IMA. However, on 7th March 2019, the petitioner was served with another show cause notice asking him to explain as to why he should not be relegated to a batch junior for having accumulated 65 restrictions in 2 consecutive terms. Thereafter, as per his claims, in an arbitrary manner, the commandant IMA relegated the petitioner from 144th regular course IMA to the 145th regular course IMA. With regard to the final physical training test, the petitioner submitted that these tests were slated for 7th November 2019 in the morning during PT time, and as he was asked to stand outside the battalion duty officer's room as a punishment with 40 kgs of sand and bricks tied to his back, he was completely exhausted and he could not perform to the best of his physical capacity. That was the reason why he failed in the 3 of the PT tests. Further, he submitted before the court that instead of providing him with another chance to clear remaining PT tests as requested, the petitioner was relegated and was ordered to be withdrawn from the IME on 23rd November 2019. In the backdrop of these facts, the petitioner sought the quashing of the withdrawal letter dated 16 January 2020 and further directions to the respondent to permit the petitioner to clear the remaining PT test and on qualifying the same to be restored to the original seniority of the 145th regular course IMA. The respondent disputed these allegations and in turn claimed that the officers at the IMA had given every kind of support to the petitioner to improve his attitude and performance, and yet the petitioner could not fit into the discipline required for a life in the Indian Army and was also found physically unfit, particularly because of being overweight, and that action has been taken strictly as per the rules, and upon the 3rd relegation, withdrawal was the only course left with the IMA. After pursuing the record, the court was of the view that the IMA had acted strictly in accordance with the rule in respect of the punishment, the relegations as well as the withdrawal. Bureau Report.
Shocked by the loot-to-own policy implemented by the high-ranking government and police officials in the Union Territory of Jammu and Kashmir to grab public land, the High Court has ordered a CBI inquiry. The bench of Chief Justice Geeta Mittal and Justice Rajesh Bindal has also directed the Union Territory administration to upload the details of the land which are in illegal and unauthorized occupation, along with identities of all influential people. The order has come in a PIL filed against the multi-crore Roshni land scam unearthed in March 2013 by the report of CAG. It was alleged that a chunk of influential population encroached upon public land by having orders passed in their favor under the Roshni Act. The bench issued following direction while ordering a CBI probe. Director CBI shall appoint teams of officers not below the rank of superintendent of police assisted by other officers to conduct an in-depth inquiry in the matters. The Anti-Corruption Bureau of the Union Territory of Jammu and Kashmir shall place complete records of all matters regarding land encroachment, Roshni Act or rules being inquired into or case investigated into by it and before the CBI, which shall proceed with the further inquiries and investigation therein accordance with the law. The CBI shall also inquire into the continued encroachment on state lands, illegal change of ownership. The CBI shall specifically inquire into the matter of publication of the Roshni Rule 2007 without the assent of the legislature. The Chief Secretary of the Union Territory Administration has been directed to monitor the matter and ensure that the inquiry by the CBI is not hampered in any manner. The Karnataka High Court has asked the state government on the need for a separate special court for the expeditious disposal of cases pending against legislators in the state. This question was posed to the state government by the division bench of Chief Justice Abhay Srinivas Oka and Justice Ashok S. Kinagi. The bench was prompted to question the state on this aspect after it heard the submission of amicus curiae and senior advocate Aditya Sondhi. Sondhi argued on the need for a separate magistrates court and court of session. He said the reason is that firstly, there are a number of cases triable by the magistrate that are clubbed together with the other cases and placed before the special court of sessions. That apart, the committal of the offence under section 193 has to take place from the magistrate. That would also be required and that a separate magistrate court be created even in respect of session offences. And agreeing with the submission, the court said, this is a very important aspect. We need to have a special court of the magistrate so that committable orders can be passed. During the course of the hearing, the court commented that a witness protection scheme will have to be put in place for these cases. When asked about the functioning of the scheme, the Additional Advocate General Dhyan Chinnappa informed the court that as of now, there was no significant implementation of the same. Apart from this, the court refused to implead NGO Association for Democratic Reform as a party in the matter. The court stated that the association could always make their suggestion to the amicus curiae. And the Karnataka High Court has said that Section 6 of 2F of the Passport Act, by which passport authority can refuse issuing of fresh passport to a person against whom criminal cases is pending in India, will not apply in cases where the applicant is seeking renewal of his passport. A bench of Justice Hemant Chandra Nagordar said a reading of Section 6(2)(f) of the Passport Act indicates that the passport authority shall refuse to issue a passport or travel document for visiting any foreign country if a criminal proceeding is pending against the applicant in India. However, he said, provision does not provide for refusing to issue a passport for a person who intends to travel back to India. Hence, reading of this provision clearly indicates that it is applicable only for issuing of fresh passport and not for renewal of passport. The petitioner Krishna Chiranjeevi Rao Palukuri Venkata had approached the court seeking direction to the authorities to allow his application dated January 22nd for renewal of his passport. The court added that the petitioner's right to travel cannot be curtailed on the pretext of a criminal case is pending against him by refusing to renew his passport. The court, while allowing the petition, took into account that respondent have not produced any document to establish that the petitioner was served with summons issued by the jurisdictional magistrate or having been issued with any notice by the authorities informing him about the pendency of the criminal case against him. The Andhra Pradesh High Court has directed the Central Bureau of Investigation to probe social media posts against judges and the judiciary. The High Court asked the CBI to examine whether the attacks on the judiciary were made as a result of larger conspiracy and, if so, take appropriate action against the culprit, irrespective of the post and position. The bench of Justice Rakesh Kumar and Uma Devi passed this order in suo motu proceeding, seeking an investigation of social media posts and regulation of content relating to the judiciary on social media. The court stated that the circumstances under which the judges were targeted needed to be investigated thoroughly, as such personal attacks were an affront to the judicial wing of the democracy, and the judges gave liberty to the CBI to register a fresh FIR if necessary, directing the High Court Registry to hand over all material, including the writ petition, to the CBI. The court also wanted the CBI to take steps to remove the alleged derogatory social media post and block the user as per the law, directing the CBI to submit a report of the probe in a sealed cover within 8 weeks. It posted the case to December 14 for further hearing. A chief metropolitan magistrate, Bandra, has ordered the discharge of 12 Indonesian nationals who were members of Tablighi Jamaat from cases registered against them on allegations that they had disobeyed government orders and thereby contributed to spread of COVID-19. Judge found that the evidence on record did not prove the charges that were levelled against them by the Mumbai police. Therefore, he has discharged the Tablighi Jamaat members from the case, directed the return of their passport and cancelled the bail bonds against them. In passing the order, the judge placed substantial reliance on the Bombay High Court judgment in Conan Kodio, Ganstone and others versus State of Maharashtra, where the Aurangabad bench had quashed similar FIRs filed against 35 Tablighi Jamaat members. Relying on the judgment and in view of the facts on record, the magistrate court concluded that there is nothing to show that the accused disobeyed the order of the central or the state government or acted negligently to spread the COVID-19 infection. The court also relied upon the charge sheet filed by the investigation officer recording that there was no evidence to show that the accused had caused spread of COVID-19 virus or the death of any person due to COVID. The court added that it did not find any breach in visa conditions either, as the accused had valid visas when they were arrested. The Chhattisgarh High Court disposed of as many as 10,000 cases during the COVID-19 pandemic. It is intimated that between the period of from March 23, 2020 till October 9, 2020, last week, the High Court disposed of a total of 10,017 cases, out of which 1,094 cases were over 5 years old. Out of the total number of disposed cases, 714 cases were disposed of by divisional benches, and of this, 416 cases were over 5 years old. Single benches constituted by the High Court during this period disposed of a total of 9,303 cases, out of which 678 were over 5 years old. During this period, the High Court observed a total of 110 working days. All type of writ petitions, civil and criminal cases were heard through video conferencing on 99 days, physical hearing on 6 days and through video conferencing, as well as physical hearing on 5 days. And that's it for Courts Roundup today. Thank you for tuning in. Keep watching APN News for more updates from around the nation.
India Legal presents Courts Roundup.